This case almost settled for the wrong number. A business valuation looked legitimate. Two experts had reviewed it. Negotiations were nearly finished. Then one ChatGPT prompt found a cash flow discrepancy buried across hundreds of pages of financial disclosures. That single finding changed the settlement number by 6 figures. This case is fictional. Every prompt is real. Every workflow reflects actual legal practice. By the end of this video, you will have a complete AI-assisted family law case management system built from intake to closing argument. 6 stages, 6 prompts, one case from start to finish. You will see every prompt word for word, every output as it generates, and how each response feeds the next one. Stay until stage 6, because that is where every previous output connects into one closing argument outline. And that connection is what most attorneys never build. Meet the fictional clients. Sarah, elementary school teacher. Michael, small business owner, married 11 years. 2 children, ages 8 and 5. The disputes: business valuation, child custody, spousal support, and property division. Sound familiar? According to the American Academy of Matrimonial Lawyers 2023 survey, 62% of family law attorneys say reviewing financial documents is the single most time-consuming task in divorce litigation. The American Bar Association reports contested divorces routinely generate between 500 and 2,000 pages of financial records requiring attorney review. Pew Research puts the annual U.S. divorce count at approximately 689,000 in 2021, the most recent year with complete national data. And the ABA's 2023 Legal Technology Survey found attorneys using AI for document review reported time savings of 30% or more on initial analysis. Business valuation disputes drive some of the highest litigation costs in family law. That is where this case starts. Stage 1, client intake. Most attorneys finish an initial consultation with pages of notes where the urgent issues and the irrelevant details are completely mixed together. This prompt separates them before legal analysis begins. The first prompt is not trying to solve the case. It is making sure nothing gets lost before the work begins. Custody issues, flagged. Separate property claim, flagged. Business valuation dispute, flagged. Retirement account classification, flagged. Discovery needs, organized. The attorney starts the case knowing exactly what questions need answers. That output becomes the raw material for every stage that follows. Stage 2, financial discovery. This is where most family law cases either settle or go to trial, and where buried discrepancies most often hide. Michael's reported business income looks consistent year over year until ChatGPT compares cash deposits against reported net income. $340,000 in deposits against $79,000 in reported net income. Equipment purchases quadrupled over 3 years. Payroll stayed flat while headcount grew. None of these facts prove anything, but together they justify a forensic accountant and a harder look at the valuation. The attorney now has a prioritized investigation list instead of 800 pages and a weekend gone. 2 stages down, 4 to go. Here is what most attorneys miss. The first 2 outputs are not just useful on their own. Stage 3 uses stage 1 facts. Stage 4 uses stages 1, 2, and 3 outputs together. Stage 6 connects all 5 into one closing argument. Prompting is asking a question. Workflow is using the answer to ask a better one. Watch what that looks like. Stage 3, child custody assessment. Custody turns on best interest factors. Every jurisdiction has them. Every case generates facts that either support or undermine them. The challenge is organizing those facts before emotions and deadlines take over. Scattered interview notes become a structured custody framework. School performance pattern, documented. Parenting schedule conflict, flagged. Missing evidence, identified before the hearing, not during it. The attorney walks into the custody conference knowing exactly where the gaps are. Stage 4, settlement framework. Most negotiations fail not because attorneys lack information, but because that information lives in 12 different places. This prompt pulls 3 stages of analysis into one negotiating position. The AI is not inventing strategy. It is organizing facts the attorney already developed across 3 previous stages. Strongest argument. The cash flow discrepancy supporting the higher business valuation. Biggest risk. The alternating custody schedule that has been in place 8 months becomes the baseline. The attorney knows exactly what to fight for and exactly what to trade. Stage 5. Trial preparation. Settlement did not resolve the business valuation dispute. The case is going to hearing. This prompt generates examination questions directly from the case record, built across 4 previous stages. The deposition just gave the attorney 3 impeachment opportunities. Cash deposits do not match reported income. Michael cannot explain the gap. Michael cannot produce documentation. The attorney still decides which questions land and in what order. But none of those opportunities get overlooked. Stage 6. The closing argument outline. Every previous stage feeds this one, not by creating new facts, by connecting facts already established. Cash flow discrepancy from stage 2 becomes a centerpiece financial argument. Scheduling conflict from stage 3 becomes the custody argument. Deposition inconsistency from stage 5 becomes the credibility argument. The attorney who built this workflow walked into that courtroom with everything organized. Not because AI gave better arguments, because AI made sure nothing got left on the intake notes from stage 1. Here is what just happened across 6 stages. The intake facts became the financial discovery questions. The financial discovery questions became the custody concerns. The custody concerns became the negotiation leverage. The negotiation leverage shaped the examination questions. The examination questions built the closing argument. Every attorney reviewing this case separately would have done good work. The attorney who built this connected workflow did something different. They made sure the cash flow problem found in stage 2 showed up in the closing argument in stage 6. That connection does not happen by accident. It happens because the workflow was designed to make it happen. 6 prompts, 1 case. Intake fed discovery. Discovery fed custody. Custody strengthened negotiation. Negotiation shaped trial preparation. Trial preparation built the closing argument. Every output stayed subject to attorney judgment. Every decision stayed with the attorney. Every filing stayed the attorney's professional responsibility. The attorney who built this system walked into settlement with a stronger hand than opposing counsel expected. Not because AI found better arguments, because AI made sure the argument buried on page 847 of the financial disclosures never got missed. Next video, the complete family law prompt library. 50 production-ready prompts organized by custody disputes, financial discovery, support issues, property division, mediation, trial preparation, and post-decree litigation. Subscribe to Legal AI Lab so you do not miss it, because the family law attorney building this system right now is creating advantages that compound with every case they take.